Okay, good morning, class. Today we have jury charge speed building. So let me give you some words that come out on your jury charge. Speed building, you have 160 to 190. And words that come out, you have Mr. Foreman is written MRFM, MRFM for Mr. Foreman. You have the evidence, TEVD, TEVD for the evidence. You have in fact is NFT, initial N, final FT for in fact. You have motor vehicle is MOEVK, MOEVK, motor vehicle. You have left hand is LND, left hand, let me see. Yes, LND with an asterisk, left hand. License is L long INS, lines for license. And then foreman by itself, you have to write, you can write foreman, form with the long O, but it's foreman, 2 strokes. And this is going to be 160, okay? Jury charge speed building. Mr. Foreman and ladies and gentlemen of the jury, as I previously stated to you, by this indictment, the defendant stands charged with driving a motor vehicle while his license to drive was suspended, that being prohibited by law of this state. Now this places upon the state, since they make that charge against this defendant, the burden of proving his guilt to your satisfaction by the evidence beyond any reasonable doubt. The burden in every criminal case is always upon the state in a criminal case to prove what it charges against the defendant beyond any reasonable doubt. It must be proved to that extent before a jury would be warranted in returning a verdict of guilty. Every accused is presumed by law to be innocent, and that innocence remains with him throughout the trial of the case until it is removed by evidence which convinces a fair and impartial jury that he is guilty beyond any reasonable doubt. Therefore, it is essential that you understand what is meant by that term, reasonable doubt. The term reasonable doubt means exactly what it says. Not just any doubt, not a fanciful doubt, not a make-believe doubt, not a made-up doubt, but a doubt that is reasonable. Sometimes we find there is substantial doubt that arises out of the evidence or lack of evidence in a case. A reasonable doubt, therefore, is simply a doubt for which a reason can be given in the exercise of good, sound, common sense, and it is to that degree that the proof must be shown by the evidence in this case before you could find this defendant guilty. The question that you will answer is, does the evidence prove to your satisfaction that this defendant is guilty of what is charged against him beyond any reasonable doubt? It is as simple as that. Now, what has or has not been proved by the evidence is for you and you alone to decide. The facts as proven by the evidence are for you and you alone to decide. Nothing that I say to you should be taken by you as being an expression on my part as to what the evidence has or has not proved. Now, the evidence consists of the testimony that you have heard, and I believe there are 1 or 2 exhibits that have been offered into evidence. They too are considered a part of the evidence and are to be considered by you. You decide what the evidence proves and apply the law to it as I charge it to you. And from that, you arrive at your verdict. And in determining what has been proved beyond a reasonable doubt, you can believe or accept all that a witness says, or you can disbelieve all or reject all that a witness says, or you can believe part and disbelieve part, accept part and disbelieve part. Credibility or believability of the testimony and evidence that is laid out before you is entirely a matter for you to pass upon. Now, turning to the law applicable to this particular crime as charged against this particular defendant, The law makes it unlawful for any person to drive a motor vehicle upon the public highways of this state when his license to drive or privilege to drive is canceled, suspended, or revoked. Therefore, to constitute the charge made against this particular defendant, the weight of the evidence must prove that the defendant did in fact drive a motor vehicle upon a public highway in this county while his license to drive was suspended. Before he could be found guilty, the evidence must prove to your satisfaction beyond any reasonable doubt that the defendant did drive a motor vehicle upon a public highway in this county when his driver's license was under suspension, if it proves that he is guilty. If it fails to prove that, the law says he is not guilty. Depending entirely upon what you determine that the evidence proves, there is only one of two verdicts that you can render, either guilty or not guilty. Whatever that verdict may be, must be the verdict of all 12 jurors. Mr. Foreman, when this jury agrees, all 12 of you, upon a verdict, it becomes your duty to write that verdict out in ink on the lower left-hand corner of this indictment on the back side. You see right where my finger is, where I am wiggling my finger there? You probably cannot see this far away, but just get up a little closer. You will see the word verdict is written there. Under that word verdict are 1, 2, 3, 4, 5 lines under it. It is in that space that you will write out the word guilty. And so real basic, you also, satisfaction is faction, S-F-A-X, it's faction for satisfaction. Guilty is G-L-T, come back E, or I, sorry. You have probably is P-R long O-B-L, probably. Highway is H-A-E, highway, H-A-E. Driver's license, D-R-L-S, driver's license, D-R-L-S. And then your verdict is Y-R-K-T, Y-R-K-T. Common sense is K-M-N-S, K-M-N-S. And this is going to be at 170. Mr. Foreman and ladies and gentlemen of the jury, as I previously stated to you by this indictment, the defendant stands charged with driving a motor vehicle while his license to drive was suspended, that being prohibited by the law of this state. Now, this places upon the state, since they make that charge against this defendant, the burden of proving his guilt to your satisfaction by the evidence beyond any reasonable doubt. The burden in every case is always upon the state, in a criminal case, to prove what it charges against the defendant beyond any reasonable doubt. It must be proved to that extent before a jury would be warranted in returning a verdict of guilty. Every accused is presumed by law to be innocent, and that innocence remains with him throughout the trial of the case until it is removed by evidence which convinces a fair and impartial jury that he is guilty beyond any reasonable doubt. Therefore, it is essential that you understand what is meant by that term, reasonable doubt. The term reasonable doubt means exactly what it says, not just any doubt, not a fanciful doubt, not a make-believe doubt, not a made-up doubt, but a doubt that is reasonable. Sometimes we find there is a substantial doubt that arises out of the evidence or lack of evidence in a case. A reasonable doubt, therefore, is simply a doubt for which a reason can be given in the exercise of good, sound common sense, and it is to that degree that the proof must be shown by the evidence in this case before you could find this defendant guilty. The question that you will answer is, does the evidence prove to your satisfaction that this defendant is guilty of what is charged against him beyond any reasonable doubt? It is as simple as that. Now, what has or has not been proved by the evidence is for you and you alone to determine. The facts as proven by the evidence are for you and you alone to decide. Nothing that I say to you should be taken by you as being an expression on my part as to what the evidence has or has not proved. Now, the evidence consists of the testimony that you have heard, and I believe there are 1 or 2 exhibits that have been offered into evidence. They too are considered a part of the evidence and are to be considered by you. You decide what the evidence proves and apply the law to it as I charge it to you. And from that, you arrive at your verdict. and in determining what has been proved beyond a reasonable doubt, you can believe or accept all that a witness says, or you can disbelieve all or reject all that a witness says, or you can believe part and disbelieve part, accept part and disbelieve part. Credibility or believability of the testimony and evidence that is laid out before you is entirely a matter for you to pass upon. Now, turning to the law applicable to this particular crime as charged against this particular defendant, the law makes it unlawful for any person to drive a motor vehicle upon the public highways of this state when his license to drive or privilege to drive is canceled, suspended, or revoked. Therefore, to constitute the charge made against this particular defendant, the weight of evidence must prove that the defendant did, in fact, drive a motor vehicle upon a public highway in this county while his license to drive was suspended. Before he could be found guilty, the evidence must prove to your satisfaction beyond any reasonable doubt that the defendant did drive a motor vehicle upon a public highway in this county when his driver's license was under suspension. If it proves that he is guilty, if it fails to prove that, the law says he is not guilty. Depending entirely upon what you determine that the evidence proves, there is only one of two verdicts that you can render, either guilty or not guilty. Whatever that verdict may be must be the verdict of all 12 jurors. Mr. Foreman, when this jury agrees, all 12 of you, upon a verdict, it becomes your duty to write that verdict out in ink on the lower left-hand corner of this indictment on the back side. You see right where my finger is, where I am wiggling my finger there? You probably cannot see this far away, but just get up a little closer. You will see the word verdict is written there. Under that word verdict are only 1, 2, 3, 4, 5 lines under it. It is in that space that you will write out the one word guilty or the two words not guilty. Once you write that verdict out, whatever it may be, then on the bottom line you sign your name, and you will see printed below the line or the bottom line the word Foreman. And you will, and don't forget, and you will is S-K-P-U-L, and you will. You've got juror is J-A-O-R, juror. You have not guilty is NOLT, N-O-L-T, not guilty, N-O-L-T. Remember, credibility, K-R-E-B-L-T, believability is B-L long E-B-L-T. Long E, sorry. Okay, one stroke. And this is going to be at 180. Mr. Foreman and ladies and gentlemen of the jury, as I previously stated to you, by this indictment, the defendant stands charged with driving a motor vehicle while his license to drive was suspended, that being prohibited by the law of this state. Now, this places upon the state, since they make that charge against this defendant, the burden of proving his guilt to your satisfaction by the evidence beyond any reasonable doubt. The burden in every case is always upon the state, in a criminal case, to prove what it charges against the defendant beyond any reasonable doubt. It must be proved to that extent before a jury would be warranted in returning a verdict of guilty. Every accused is presumed by law to be innocent, and that innocence remains with him throughout the trial of the case until it is removed by evidence which convinces a fair and impartial jury that he is guilty beyond any reasonable doubt. Therefore, it is essential that you understand what is meant by that term reasonable doubt. The term reasonable doubt means exactly what it says. Not just any doubt, not a fanciful doubt, not a make-believe doubt, not a made-up doubt, but a doubt that is reasonable. Sometimes we find there is substantial doubt that arises out of the evidence or lack of evidence in a case. A reasonable doubt, therefore, is simply a doubt for which a reason can be given in the exercise of good, sound common sense. And it is to that degree that the proof must be shown by the evidence in this case before you could find this defendant guilty. The question that you will answer is, does the defendant prove to your satisfaction that this defendant is guilty of what is charged against him beyond any reasonable doubt? It is as simple as that. Now, what has or has not been proved by the evidence is for you and you alone to determine. The facts as proven by the evidence are for you and you alone to decide. Nothing that I say to you should be taken by you as being any expression on my part as to what the evidence has or has not proved. Now, the evidence consists of the testimony that you have heard, and I believe there are 1 or 2 exhibits that have been offered into evidence. They too are considered a part of the evidence and are to be considered by you. You decide what the evidence proves and apply the law to it as I charge it to you. And from that, you arrive at your verdict. And in determining what has been proved beyond a reasonable doubt, you can believe or accept all that a witness says, or you can disbelieve all or reject all that a witness says, or you can believe part and disbelieve part, accept part and disbelieve part. Credibility or believability of the testimony and evidence that is laid out before you is entirely a matter for you to pass upon. Now, turning to the law applicable to this particular crime as charged against this particular defendant, the law makes it unlawful for any person to drive a motor vehicle upon the public highways of this state when his license to drive or privilege to drive is canceled, suspended, or revoked. Therefore, to constitute the charge made against him, this particular defendant, the weight of the evidence must prove that the defendant did, in fact, drive a motor vehicle upon a public highway in this county while his license to drive was suspended. Before he could be found guilty, the evidence must prove to your satisfaction beyond any reasonable doubt that the defendant did drive a motor vehicle upon a public highway in this county when his driver's license was under suspension, if it proves that he is guilty. If it fails to prove that, the law says he is not guilty. Depending entirely upon what you determine that the evidence proves, there is only 1 of 2 verdicts that you can render, either guilty or not guilty. Whatever that verdict may be, must be the verdict of all 12 jurors. Mr. Foreman, when this jury agrees, all 12 of you upon a verdict, it becomes your duty to write that verdict out in ink on the lower left-hand corner of this indictment on the back side. You see right where my finger is, where I am wiggling my finger there. You probably cannot see this far away, but just get up a little closer. You will see the word verdict is written out there. Under that word verdict are 1, 2, 3, 4, 5 lines under it. It is in that space that you will write out the 1 word guilty or the 2 words not guilty. Once you write that verdict out, whatever it may be, then on the bottom line you sign your name and you will see printed below the line the word Foreman. And you will have this indictment in the room with you and also have 2 exhibits. You will, and wiggling is just wiggling, LG. You have indictment is D long I-M-T, indictment, D long I-M-T. You have let me see. Don't forget exercise, K-P-E-R-Z, exercise. And then I think that's it. Pretty easy, you all. This is going to be at 190, okay? And then we'll have your test, 190. Mr. Foreman and ladies and gentlemen of the jury, as I previously stated to you by this indictment, the defendant stands charged with driving a motor vehicle while his license to drive was suspended, that being prohibited by the law of this state. Now, this places upon the state, since they make that charge against this defendant, the burden of proving his guilt to your satisfaction by the evidence beyond any reasonable doubt. The burden in every criminal case is always upon the state, in a criminal case, to prove what it charges against the defendant beyond any reasonable doubt. It must be proved to that extent before a jury would be warranted in returning a verdict of guilty. Every accused is presumed by law to be innocent, and that innocence remains with him throughout the trial of the case until it is removed by evidence which convinces a fair and impartial jury that he is guilty beyond any reasonable doubt. Therefore, it is essential that you understand what is meant by that term, reasonable doubt. The term reasonable doubt means exactly what it says, not just any doubt, not a fanciful doubt, not a make-believe doubt, not a made-up doubt, but a doubt that is reasonable. Sometimes we find there is substantial doubt that arises out of the evidence or lack of evidence in a case. A reasonable doubt, therefore, is simply a doubt for which a reason can be given in the exercise of good, sound common sense, and it is to that degree that the proof must be shown by the evidence in this case before you can find this defendant guilty. The question that you will answer is, does the evidence prove to your satisfaction that this defendant is guilty of what is charged against him beyond any reasonable doubt? It is as simple as that. Now, what has or has not been proved by the evidence is for you and you alone to determine. The facts as proven by the evidence are for you and you alone to decide. Nothing that I say to you should be taken by you as being any expression on my part as to what the evidence has or has not proved. Now, the evidence consists of the testimony that you have heard, and I believe there are 1 or 2 exhibits that have been offered into evidence. They too are considered a part of the evidence and are to be considered by you. You decide what the evidence proves and apply the law to it as I charge it to you, and from that you arrive at your verdict. And in determining what has been proved beyond a reasonable doubt, you can believe or accept all that a witness says, or you can disbelieve all or reject all that a witness says, or you can believe part and disbelieve part, accept part and disbelieve part. Credibility or believability of the testimony and evidence that is laid out before you is entirely a matter for you to pass upon. Now, turning to the law applicable to this particular crime as charged against this particular defendant, the law makes it unlawful for any person to drive a motor vehicle upon the public highway of this state when his license to drive or privilege to drive is canceled, suspended, or revoked. Therefore, to constitute the charge made against this particular defendant, the weight of the evidence must prove that the defendant did in fact drive a motor vehicle upon a highway in this county while his license to drive was suspended. Before he could be found guilty, the evidence must prove to your satisfaction beyond any reasonable doubt that the defendant did drive a motor vehicle upon a public highway in this county when his driver's license was under suspension. If it proves that, he is guilty. If it fails to prove that, the law says he is not guilty. Depending entirely upon what you determine that the evidence proves, there is only one of 2 verdicts that you can render, either guilty or not guilty. Whatever that verdict may be must be the verdict of all 12 jurors. Mr. Foreman, when this jury agrees, all 12 of you, upon a verdict, it becomes your duty to write that verdict out in ink on the lower left-hand corner of this indictment on the back side. You see right where my finger is, where I am wiggling my finger there. You probably cannot see this far away, but just get a little closer. You will see the word verdict is written there. Under that word verdict are 1, 2, 3, 4, 5 lines under it. It is in that space that you will write out the word guilty of the 2, or the 2 words not guilty. Once you write that verdict out, whatever it may be, then on the bottom line you sign your name and you will see printed below the bottom line the word Foreman. And you will have this indictment in the room with you and also have 2 exhibits. You will have the 2 exhibits in the jury room with you, and you can look at those 2, and also you can read the indictment. Okay, and we'll get ready for your test. Jury room real quickly is J-U-R-M, J-U-R-M. Okay, let's get ready for your test, you all. Okay, so now we're gonna do your tests. We have your 180 test number 1 jury charge. Let me give you words that come out. None. Okay, so it says no proper names. This is going to be test number 1, 180 for 5 minutes. And let me just make sure I don't see anything. No. 5 minutes, 180. Gentlemen, as you go to your deliberations, I want to remind you again that you must view only the evidence that has been given to you in this case. That evidence consists of the words of the witnesses, the exhibits which have been marked in evidence, and 2, the agreements or admissions made by the parties and or their counsel. Then you may, of course, draw inferences and conclusions based upon your common experiences in life. But these inferences and findings must be founded upon the evidence given at this trial. It is not for you to guess. It is not for you to speculate. It is not for you to conjecture. You must always use your basic intelligence. Bear in mind that the questions asked by counsel are not evidence. The opening addresses of counsel and the summations of counsel at the end, and any comments which may have been articulated by them during the course of the trial, are not evidence, nor is my recital of the facts to you to be assumed accurate where it conflicts with your memory of the facts as shown by the testimony, the exhibits, and other matters I have just outlined. You should not even permit yourselves to be influenced by any reference to the testimony which I have just made or which I may make. It is my duty to be the sole judge of all the matters of law. It is your duty and yours alone to decide the facts. When I made reference to any facts, I was doing so just by way of showing or for the purpose of convenience and not to intimate more or less importance to that evidence. You will undoubtedly recollect that during the course of the trial, I made rulings on objections and motions of counsel. Sometimes I denied, sometimes I granted, sometimes I sustained, and sometimes I overruled. Do not get the impression from that I have any opinion. I may have, but that opinion does not and will not be obvious to you because you are the judges of facts, not I. I certainly have in no way expressed to you, nor will I express to you any belief as to how you should decide this case. Those rulings I made were based on the law alone, and such matters are exclusively within my province, just as the determination of the facts is within your province. Since you are the sole judges of the facts in the case, it then follows that you are also the exclusive judges of the credibility of the witnesses. It becomes your duty to weigh the truth of their testimony. In your search for the truth, you will have to determine whether or not you will give credence to the testimony of one witness over that of another witness. You have seen each witness on the stand and observed the manner in which he gave his testimony. How did the witness impress you? Was he frank? Was he evasive? Did his version appear to be straightforward? Did he attempt to conceal some of the facts? Was he honest, or was he biased or prejudiced? Was he interested in the outcome of the case? Those are questions you should ask yourselves as jurors. If you find from the evidence in this case that anyone has knowingly testified falsely to a germane fact, you will of course reject that part of the testimony. In addition, you may, if you so choose, reject and ignore all the testimony of such witness, or you may, while rejecting that part of the testimony which was surely false in your mind, take the rest of his testimony. What you do in that respect is entirely up to you. It is for you and you alone to determine how much to believe and what to believe. It is for you and you alone to determine what weight should be given to the testimony of any witness. It is apparent that this suit is what we refer to in law as a negligence case. In order to reach a verdict for the plaintiff, it is incumbent upon the plaintiff in such an action to prove by a fair preponderance of the credible evidence that the three propositions which I will now give you are true. You are to take these instructions as the law, whether or not you, in your own mind, agree or disagree with me. The plaintiff must show first that the defendant was careless, second, that the plaintiff himself was free from contributory negligence, and third, that the harm caused to the plaintiff flowed directly from the defendant's actions. This third statement has been referred to by counsel as a causal relationship. Let us look now to the word negligence as defined by the law. It means carelessness. Simply, negligence means the failure or omission to do an act or to perform some duty which one person owes to another, or the commission of some act by a person which, in the exercise of due care, he should not have committed. It is also defined as the failure or omission to do what a person of usual and ordinary care and prudence would have done under the same or like conditions. Under our law, there is no fixed true standard of care. The care to be used is always proportionate to the, and then you have your second test, proper names. It says none. So on your 180 number 2, no proper names. Okay, and this is going to be 180 number 2 for 5 minutes jury charge test. Ladies and gentlemen, as jurors, you are the judges of the evidence in this case. You are what we call the finders of the facts in the case before us today. What you decide is the truth in this proceeding will be what is referred to as a verdict. In order to reach a reasonable and fair verdict, you must be aware of certain principles of law that apply to the case at hand. Now, I'm sure that many of you have seen trials on television or in the movies. It is important to remember, though, that what you have seen in those cases is not necessarily how the law is written. It is often more fiction than fact. So I will direct you to pay careful attention to the instructions I am about to give to you. And you must follow those instructions to the letter, even if you disagree with them or had thought the law was something other than what I tell you about it here today. In reaching your verdict in this case, you must not let any bias or prejudice for either side to enter into your decision-making process. What we are searching for here is the truth. Therefore, bias and prejudice have no place here in this court. The plaintiff in this case has come into court seeking a monetary award for damages from the defendant. It is your duty, first of all, to decide if the defendant acted in a negligent way and was the cause of the car accident we have heard about in this trial. You must be convinced that the defendant was the proximate cause of this accident by a fair preponderance of the evidence. Now, what do we mean by a fair preponderance of the evidence? It is a very simple yet important rule. You must be convinced that it is more likely true than not true, and that the defendant, by his actions, was responsible for the occurrence of the accident. Imagine in your minds a set of scales. On one side, you have the facts as given by the plaintiff, and on the other side of the scales, you have the facts as given by the defense. Now, we are not talking about the greater number of witnesses or the physical amount of evidence, but the quality of the evidence. If the scales tip in favor of the plaintiff, then you should return a verdict accordingly. If the scales do not tip in favor of the plaintiff, then your verdict must be for the defense. If you find in favor of the plaintiff that the defendant was negligent in this case, then you shall award actual damages if they have been proved by a greater weight of evidence. The amount you award, if any, must compensate the plaintiff for injury, loss, and damage. In fixing damages, you may note any non-monetary losses that have been had at this time or are likely to be had in the future. In this group, you should not think about any real damages for physical harm. These will be in another group. The type of losses you should consider here are things such as pain and suffering, mental injury, inconvenience, and the loss of enjoyment of life in things such as hobbies or recreation. In fixing damages, you may also note economic losses that have been sustained at this time or are likely to be sustained in the future. This would include things like doctor's fees, hospital fees, property loss, and things of this type. You should also consider as damages any physical loss sustained by the plaintiff. This would not have been included in what I have listed before. The law is fully aware of the trouble of turning some injuries into a dollars and cents figure, but that is what must be done. You must award a figure that will fairly and amply compensate the plaintiff for the damages he has already suffered and that he will in all likelihood suffer in the future. Now, I do not mean to infer that I have an opinion one way or the other about whether the plaintiff was negligent, and if he was, whether the defendant suffered any damages. I must give you these rules in case that is what you decide. If you should decide that the plaintiff was not at fault, or if the defendant was not damaged, then you should return a verdict in favor of the plaintiff and ignore what I have said about the different types of damages. In your decision, you should view only the evidence, that is, the words of the witnesses and the exhibits I have allowed in the record. But as you view the evidence, both direct and indirect, you may make deductions and reach conclusions which reason and common sense lead you to make. Direct evidence is the statement of one who claims actual knowledge of a fact, such as an eyewitness. Circumstantial evidence, that is proof of a chain of facts and events tending to prove or disprove a final conclusion. Now that what the lawyers say is not evidence in the case. It is your own recall and understanding of the evidence that controls. Now, in saying that you must consider all of the evidence, I do not mean that you must accept all of the evidence as true. And then you have your 160s, you all. And so you have your 160 number 1 test, proper names, none. Okay, so no proper names. This is going to be 160 jury charge number 1 for 5 minutes, you all. All right, members of the jury, we've reached the stage in the trial where I will instruct you on the law and also a little bit on procedures, how you can operate in the jury deliberation room. Keep in mind that we are here for one purpose, and that is to discover the truth. And once we discover the truth, you apply the law and administer justice accordingly. The division of effort between us is pretty clear. Your function is exclusively to determine the facts. To put it another way, ascertain what the truth is in this matter. My part in the division of effort is to explain the principles of law to which you apply the facts which you find. Your first order of business in the jury room will be to elect your own foreperson. The foreperson will have the duty to chair your deliberation, and upon reaching your verdict, report that verdict to us here in open court. If it should become necessary, a foreperson will be your spokesman here in open court. After you have selected your foreperson, the next order of business will be to review the evidence and determine from it the facts. What happened? Once you have decided the facts, you will apply those facts to the law that I am in the process of giving you. And this way you will be able to reach your verdict. The verdict reached by you must be unanimous. All of you must agree. Any verdict which does not reflect the view of each of you and is not unanimous is improper and cannot be accepted. While you're deliberating, each of you has a duty to consult with the others and to deliberate upon questions presented, in this case, with a view to reaching an agreement if you can do so without doing violence to your own individual judgment or judgments. It almost goes without saying that each juror must decide the case for himself or herself, but only after an impartial consideration of the evidence with your fellow jurors. In the course of deliberations, each of you should not hesitate to re-examine your own view and change your opinion if you are convinced that your original view is erroneous. However, and this is important, no juror should surrender his or her honest view as to the weight or effect of the evidence solely because of the opinion of any fellow juror or jurors, or for the mere purpose of returning a verdict. In determining the facts, you must keep in mind that during a jury trial, nothing becomes a true fact until you, the jury, collectively decide what is fact and in some cases what is not fact. Counsel in their closing arguments have commented upon the evidence, and in so doing they have depended upon their individual recollection of the evidence. However, it is your collective recollection which controls when you deliberate upon what is fact and what is not fact. If your recollection differs in any way from the recollection of counsel, and I hasten to add the court, if I should refer to the facts and your recollection differs from mine, you will be guided by your own recollection. You do not take the facts from counsel or from the court. You are the sole determiners of the facts. In determining the facts, you may come across conflicts in the evidence, conflicts in the testimony, and if you do, you have the duty to decide which testimony to believe and accept. First, however, you should try to reconcile or fit together any conflicts in the testimony if you can fairly do so. Discrepancies and conflicts between the testimony of different witnesses may or may not cause you to disbelieve some or all of their testimony. Remember that two or more persons witnessing an occurrence or an incident may see or hear it happen differently. Also, it is not uncommon for witnesses to be innocently mistaken in his or her recollection of how something happened. If you cannot reconcile a conflict in the testimony, it is up to you to decide which testimony, if any, to believe and which to reject as untrue or inaccurate. In making this decision, consider whether the conflict involves a matter of importance or merely some detail, and whether the conflict is brought about by an innocent mistake or an intentional falsehood. In deciding which of the conflicting testimony to believe, you should not necessarily be swayed by the number of witnesses on either side. You may find the testimony of a few witnesses or even just one witness more believable than opposing testimony of a greater number of witnesses. Now, as I mentioned before, the facts recited by counsel are not facts unless you find them to, and capitalize court on that one when you can replace judge in the sentence, okay? And then we've got 160, number 2, and it says note takers is hyphenated and lowercase apostrophe s for takers. This is 160, number 2 for 5 minutes. Members of the jury, you have heard all the evidence, and now it is my duty to instruct you on the law that applies to this case. The law requires that I read the instructions to you in open court. You will have these instructions in written form in the jury room to refer to during your deliberations. You must base your decision on the facts and the law. You have 2 duties to perform. First, you must determine what facts have been proved from the evidence received in the trial and not from any other source. A fact is something proved by the evidence or by stipulation. A stipulation is an agreement between attorneys regarding the facts. Second, you must apply the law that I state to you to the facts as you determine them, and in this way arrive at your verdict. You must accept and follow the law as I state it to you, regardless of whether you agree with the law. If anything concerning the law said by the attorneys in their arguments or at any other time during the trial conflicts with my instructions on the law, you must follow my instructions. You must not be influenced by pity for or prejudice against a defendant. You must not be biased against a defendant because he has been arrested for this offense, charged with a crime, or brought to trial. None of these circumstances is evidence of guilt, and you must not infer or assume from any or all of them that a defendant is more likely to be guilty than not guilty. You must not be influenced by sentiment, conjecture, sympathy, passion, prejudice, public opinion, or public feeling. Both the people and the defendant have a right to expect that you will conscientiously consider and weigh the evidence, apply the law, and reach a just verdict regardless of the consequences. If any rule, direction, or idea is repeated or stated in different ways in these instructions, no emphasis is intended, and you must not draw any inference because of its repetition. Do not single out any particular sentence or any individual point or instruction and ignore the others. Consider the instructions as a whole and each in light of all the others. The order in which the instructions are given has no significance as to their relative importance. Statements made by the attorneys during the trial are not evidence. However, if the attorneys have stipulated or agreed to a fact, you must regard that fact as proven. If an objection was sustained to a question, do not guess what the answer might have been. Do not speculate as to the reason for the objection. Do not assume to be true any insinuation suggested by a question asked a witness. A question is not evidence and may be considered only as it helps you to understand the answer. Do not consider for any purpose any offer of evidence that was rejected or any evidence that was stricken by the court. Treat it as though you had never heard of it. You must decide all questions of fact in this case from the evidence received in this trial and not from any other source. You must not independently investigate the facts or the law or consider or discuss facts as to which there is no evidence. This means, for example, that you must not on your own visit the scene, conduct experiments, or consult reference works or persons for additional information. You must not discuss this case with any other person except a fellow juror, and then only after the case is submitted to you for your decision, and only when all 12 jurors are present in the jury room. You have been given notebooks and pencils. Leave them on your seat in the jury room when you leave each day, and at each recess, you will be able to take them into the jury room when you deliberate. Notes are only an aid to memory and should not take precedence over recollection. A juror who does not take notes should rely on his or her recollection of the evidence and not be influenced by the fact that other jurors do take notes. Notes are for the note taker's own personal use in refreshing his or her recollection of the evidence. Finally, should any discrepancy exist between a juror's recollection of the evidence or his notes, or between one juror's recollection and that of another, you may request that the reporter read back the relevant testimony, which must prevail. Evidence consists of testimony of witnesses, writings, material objects, or anything presented to the senses and offered to prove the existence or non-existence of a fact. Evidence is either direct or circumstantial. Direct evidence is evidence that directly, and you also don't forget on this last one, capitalize people, court when you can replace judge, and people when you can replace prosecution, okay? That's it, you all. Have a great day. Type them up, see how you're doing. They were very fair.